We begin tonight with a story that's making waves worldwide. President Trump authorizing U.S. forces to strike and sink fishing boats suspected of smuggling drugs in international waters. Now, supporters call it decisive action. Critics call it legally shaky and dangerously escalatory. The U.S. has been sinking the suspected drug runners in international waters on Trump's direct orders. Now, the legality is disputed under international maritime law and U.S. constitutional authority. Congress has not granted explicit approval, raising questions about presidential overreach, and that's not the first time that phrase has come in. Critics warn the U.S. has provided little public evidence the boats were actually carrying drugs. So, why does it matter? Well, this is a rare instance of a major power using military force against civilian fishing vessels outside wartime. What the U.S. does here sets precedents that could be invoked by other nations, including adversaries. And it has big implications for maritime law, sovereignty, and global drug interdiction norms. So let's get down to business and just have a look at the arguments that are for it from a legal perspective. The U.S. can act under long-standing drug interdiction authorizations that don't require congressional approval. Maritime law allows interdiction of stateless vessels suspected of trafficking. And national security urgency can justify immediate presidential action. There's a lot of kind of openings there that you could drive a Mack truck through, I'm sure.
Pretty much.
So, against. International law requires clear evidence a vessel is engaged in illicit activity, evidence the U.S. has not presented publicly. As a matter of fact, there's been very little evidence at all, other than a couple of pictures they have released. Sinking a civilian vessel is arguably excessive force inconsistent with maritime proportionality rules. In Congress, not the president, once again, here we go, Congress, not the president, holds war-making powers, and lethal force against non-military targets may exceed executive authority. Right. So, moving on from that, I decided I'd play a little what if. What would Canada do if the U.S. sank a vessel in our territorial waters? And if you think that's out of the question, give your head a shake, because It's not. So, what if? Well, number one, we would demand a formal investigation and a formal explanation through the U.S. State Department, the U.S. ambassador in Ottawa, good luck with that one, and or a formal diplomatic note. Now, this step establishes the legal record that Canada sees the action as a violation of sovereignty, which it is. Number two, public condemnation and summoning the ambassador. This is standard when an ally crosses a line. Canada could publicly condemn the action, then summon the U.S. ambassador in Ottawa for an explanation. Number three, demand a joint investigation and request the White House clarify whether the order came directly from President Trump. This signals seriousness with escalating militarily. Canada could, as I say, request or insist on a binational investigation, Canada and the U.S., including access to U.S. intelligence, claiming the vessel was carrying drugs, a reconstruction of events such as location, warning shots, identification, and so on. And if the U.S. refuses, it becomes a much bigger political issue. Number four, invoke international maritime law, giving Canada the option of taking legal or diplomatic action through the UN Convention of the Law of the Sea, or the International Maritime Organization. Canada's position would be, even if the boat was carrying drugs, the U.S. had no right to use lethal force in Canadian territorial waters without our explicit consent. Okay, let's move on to the next grouping. Number 5, NORAD and military implications. All right. We could quietly or publicly demand a review of NORAD operating rules, new restrictions on U.S. maritime or aerial operations near Canadian waters, a have to no joint naval exercises until the matter is resolved, and while allies, this incident definitely would trigger serious defense policy conversations. Number 6, temporary freeze on cooperation. Without fully breaking cooperation, Canada could suspend certain intelligence sharing lines, pause joint maritime patrols, slow or freeze cross-border law enforcement operations like the RCMP and the DEA and the RCMP and the U.S. Coast Guard. This would be a strong signal without harming long-term alliances. Number 7, potential legal action. Canada could pursue International Court of Justice action if the U.S. agreed to jurisdiction, which is highly unlikely. Compensation claims if the crew was comprised of Canadian nationals, and wrongful death or negligence investigations, even if symbolic. These actions carry political weight. And number 8, escalatory options unlikely but technically available. Canada has the right to escort U.S. vessels out of Canadian waters, deploy the Royal Canadian Navy to the area, and challenge U.S. claims publicly. Now, these would be last resort measures because they risk military tension with our once closest ally. So,
and that point is important.
Very much important. Very, very much so important. So, we go from there to realistically, if this happened, what would the real life sequence be? Okay, well, there are a couple of things. I've got notes all over the place. The first one would be demand, again, immediate diplomatic explanation. And, you go all through these things again. But the most likely response, realistically, would be this. Number 1, immediate Canadian protest. Number 2, a demand for the joint investigation. Number 3, insistence on seeing U.S. intelligence. Number 4, public criticism, but controlled tone. Number 5, a negotiated resolution where the U.S. expresses regret, offers compensation, and promises better coordination. I promise to be a good boy going forward.
Yeah, exactly.
Yeah. Canada would almost certainly avoid open military confrontation, but it would not let the issue slide. So that is where we stand on that aspect of it.